Hi everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. This is week 7 and we're looking at chapter 10 dealing with remuneration. The reason we all go to work, so we get paid. The reading from this week, for this week is from chapter 10 from Stewart's Guide. Nice short chapter but plenty of interesting material in it. So these are my hints and comments about the sorts of things that I think are worth noting from this week's reading from Stewart's Guide. First of all, be aware of the different types of remuneration. Most people are paid by time basis, so the number of hours that we put in each week is equated back to the pay that we receive. And you'll see later on that in the national wage case, for example, there's a reference to hourly rates and then hourly rates plus additional amounts for penalties, etc. Piece rates. Not an unusual way to be paid, and the textbook authors refer to the situation where a courier is paid by the number of items that he or she delivers during a day, so paid on a piece rate basis. And then finally, a reference to an annual salary. So some people, particularly at the professional or managerial level, negotiate a salary which is effectively the total amount that they're going to receive for the year. It's going to be well above the award rates, so it's out of the reach of penalty provisions, etc. And they are paid on an annual basis, which is then divided either into fortnightly, monthly, what have you. There, of course, is always provision for additional payments, and most of us are familiar with things such as bonuses or incentives. Note the comment there that the bonus or incentive is very much a contractual thing. So that means that you really need to nail down the terms and conditions under which the bonus or the incentive is going to be paid, because often they're very much based on discretion. All sorts of bonuses and incentives. You sometimes hear about people receiving a bonus or an incentive just to re-sign a contract or continue with a company. They're sometimes called a golden handcuff. So you will receive a bonus or an incentive if you're still working with the company in 12 months' time. And then under awards or agreements, there are additional payments which are not contractual in nature. These are legislative. So loading and penalty rates for doing particular work or doing work at particular times, and special allowances. If you have a look at the enterprise agreement, which I put up on the Moodle page for the university, for example, you'll see a list of allowances there for doing what's probably dirty work. Salary sacrifice, again, not available to everybody, and there's probably two things that you'd need to look at in your workplace. One is whether or not the fringe benefits tax, which is likely to be paid, is going to leave everyone better off than paying the marginal rate. So for that reason alone, not always going to be of benefit to an employee who's not right up there paying that top marginal rate. But in some circumstances, particularly where the particular industry attracts concessions or is exempt from fringe benefits tax, it's going to be worthwhile. And so you'll see that, and I think there's a reference in the text as well to businesses like the Community Legal Centre that I volunteer at. Its staff can attract concessional or exemption in some cases for fringe benefits tax. So a number of them have taken the opportunity to sacrifice part of their pay so that the centre pays, for example, school fees and mortgage payments, and they receive the balance in the usual way. The packages might be more valuable, but they cost the same, and usually they're allowed for in an award or an agreement. And you'll see why in the text, and that is that technically wages are not being paid in full if deductions are being made. So rather than leave that question at large, allowing for it in the award or agreement makes it clear that it's an authorised deduction. The text deals in some detail with wage fixing. These are my comments on what I think are the important issues with respect to wage fixing. have a look at the history of where it came from and how it used to be. But jumping ahead to the work choices reforms, you'll see that on an annual basis, the Fair Work Commission gets together an expert panel to look at setting wages for the following year. Under Section 620 of the Fair Work Act, that panel is comprised of 7 members, so the President, 3 ordinary members, and then 3 experts chosen from these fields. They have to have expertise in at least one of these fields, says Section 620. So social policy, economics, business, industry or commerce, and workplace relations. So that panel will get together and set minimum wages for the following 12 months. Section 285.2 says they'll also set an annual wage for modern awards and the national minimum wage. And here's Section 284 in Part 2.6. It talks about the minimum wage objective. So what's the minimum wage objective? Fair Work Commission must establish and maintain a safety net of fair minimum wages taking into account, and then there's a list of 5 things: performance and competitiveness of the national economy, promoting social inclusion, relative living standards, principle of equal remuneration for work of equal and comparative value we'll come back to, and providing a comprehensive range of fair minimum wages to juniors, to employees who are undergoing training, and employees with a disability. And again, we'll mention that further in the course. There's also a national minimum wage order that's made by the Fair Work Commission, and it's made for award or agreement-free employees. Again, it's done annually, and like the previous review, it comes into effect on the 1st of July every year. Have a look at Section 286. The Commission, in making that national wage order, is looking at issues like casual loading, juniors, trainees, and employees with disability. State awards used to follow, to some extent, the national award, and you'll see a reference in the text to a real breakaway when they started to issue their rulings prior to the Commonwealth ruling. But generally, I think as much as you need to know is there's no automatic flow on between the Commonwealth and the state. The states have never been obliged to do that anyway, but they no longer automatically flow on. And in some jurisdictions, the commissions must consider government policy on public sector employment conditions. Just harking back to something we looked at in the first couple of weeks, you might recall that in most cases, the Constitution said that where the state was handing over its rights, there were some issues it just couldn't, and certainly choosing the numbers, the makeup of the workforce, etc., is something that's beyond the Commonwealth powers. And so here, I guess in tune with that, the states are saying, well, we're going to pass policies on public sector employment conditions, and we want our commissioners to take those into account. Some interesting comments in the text regarding pay equity. Certainly there's a reference there to a 1951 ruling from the ILO on equal remuneration, and there's a link on the slides to that ruling if you want to have a look at it. Just note that comment though that although this has been kicking around since 1951, and although there have been great leaps forward with respect to, say, Indigenous employees, the issue that men and women should be paid the same for the same job for many years now, equal pay for work of equal value is not exactly the same as equal pay for work of comparable value. So in the first one, you're looking at people doing the same or pretty much the similar job. In the next one, it's looking at 2 different jobs and seeing how they compare. And there's some great comments in the text about why that is important, why that's an issue. The Fair Work Act attempts to address that. If you look at Section 284.1 in working out the minimum wages objective, item D refers to the principle of equal remuneration for work of equal or comparable value. And have a look also at Part 2.7 in the Act. Under 302, Fair Work Commission can make an order requiring equal remuneration. And you see an example of that given in the text where the Commission had a close look at the Sachs Award some years ago now, and gave a fairly serious set of pay rises over a period of time, ostensibly to bring those wages up to wages which were comparable to work of equal of equal or comparable value. So an interesting decision if you want to have a look at that one. Now let's talk about earning remuneration. What do you have to do? Well, the big issues I think you need to take note of are these. All sorts of rules about standing people down or suspending without pay for two reasons. One is that these things do happen reasonably often, and secondly that employers often get themselves in a tangle because there's no general right to do that. You can't generally just stand someone down because you don't want to run your operation for a couple of weeks, and you can't suspend them without pay. Of course, slightly different, of course, to asking people to take leave at a particular time. This is suspending people without pay or standing them down. And the safest way for employers to deal with that is to either have it in an award or in an agreement, and that includes a contract. So to talk about the capacity to stand down or suspend without pay. Have a look in Part 3.5 of the Fair Work Act at Section 524. And that section deals with when a person can be stood down. So in Division 2, it's headed up circumstances allowing a stand down. An employer may stand down employees in certain circumstances. So clearly that's a change from the common law, and then the circumstances are outlined. An employer may, under this subsection, stand down an employee during a period in which the employee cannot usefully be employed. So that's the first thing. There has to be no useful employment they can be doing because of one of the following circumstances. Industrial action, and that's obviously other than a lockout by the employer. A breakdown of machinery or equipment, if the employer cannot reasonably be held responsible for the breakdown. And a stoppage of work for any cause for which the employee cannot reasonably be held responsible. And then they give, the Act gives a couple of examples where they may not stand them down. During a period in which the employee cannot usefully be employed because of circumstances referred to in that subsection, if an enterprise agreement or a contract of employment applies to the employer and the employee, and the agreement or the contract provides for the employer to stand down the employee during that period, if the employee cannot usefully be employed during that period because of that circumstance. So, interesting. In other words, it can be contracted out of in an enterprise agreement. So ordinarily, you're starting from the proposition that you just can't stand people down. Then the Act comes in Section 524 and says you can stand them down in these circumstances. However, you can't stand them down under those circumstances if an enterprise agreement or a contract applies and it says that you can't do it. So, interesting point. Not required to pay an employee during a period of standing down. And I guess that's why it's been contentious over the years. So, by implication, then, you can't stand people down just because you run out of work or because you're undertaking scheduled maintenance. The text also refers to the question of no work, no pay, and I think everybody's probably heard that term used from time to time. So even where someone is wrongfully prevented from working, as was in the automatic fire sprinklers case, their remedy was to claim damages for breach of contract. They couldn't say that the wage bill was continuing to tick over, although there's probably not much difference between the two. And that was confirmed recently in Cole and Allied and McPherson. So it's seen as it's seen as a fairly rigid rule. I would think that no work's done, no pay accumulates. And note also, under Part 3.3 of the Fair Work Act, it is now prohibited to pay employees during a period of industrial action. Now, this is an issue, gardening leave is an issue which comes up often, and some very interesting cases in the section which deals with paying employees not to work. Now, that's paragraph 10.22 in your text, and I would urge you to have a look at that section because that comes up more often than you would think. Now, this is the situation where, for a variety of reasons, an employer is sent home. So sometimes they might be sent home. There's been a falling out and they're being paid out their period of notice, so they're being asked to serve it out at home. They don't want to release the employee to go and work for a competitor, but they prefer not to have them around. That's where the relationship's broken down. Now, you'll see examples in paragraph 10.22 around why that did not used to apply, for example, to performers and actors, etc. They didn't want their careers to stagnate. But more generally, gardening leave was thought to be something that an employer could do. The person wasn't being unnecessarily prejudiced. But have a look at the case of Down and Sydney West Area Health. The director of the hospital unit couldn't really be held out from working indefinitely, so that the director couldn't use the skills that they had. Her contract was interrupted because they were looking at investigating a matter, and it was really dragging on for quite some time. Just rounding out that paragraph 10.22, note the comments with respect to Seven Network and Warburton. Still safer to include such a provision in a contract rather than try and assume that just because the employee is not being prejudiced financially, that there is a right to stand people down. Payment of wages, I think we've spoken about previously in relation to enforcement, but just to revise that, Section 536 talked about the information which people need to be given on a regular basis, and you might recall they're set out in a regulation to the Act. Have a look at that one again and remind yourself. Section 323, though, says you've got to be paid in money, so you can't receive other benefits, you must be paid in money. You've got to be paid at least once a month, and then remember that provision for being paid in full and also in an agreed method, so by direct payment into your bank account, by cheque, by cash, whatever. Look at the section in the Fair Work Act which deals with deductions, and that's section 324. My take on this is I think these are the three main things. They really need to be authorised in writing, and principally for the employee's benefit, authorised by an award or agreement, or authorised by a law of the Commonwealth, state, or order of a court. So deductions, I think employers should be very wary of making any sort of deduction from wages without getting something in writing. And even then, there is that second rider about principally being for the employee's benefit. It is an inquiry that you will deal with quite often about deduction of wages. The importance of Section 323, just to come back to that section again, is that it means that where someone is not paid in full, even under a contract of employment, Section 323 is available to them to bring on a civil penalty as well as their claim for unpaid wages. And the textbook refers to the appeasement case as a good example of that. So when there's been an overpayment or a set-off, remember, always come back to that 323, and that is that employers cannot just start deducting a small amount from people's wages. Theoretically, they might even need to go so far as to get a judgment from a court for the repayment of the amount. It really should be in writing and by negotiation. And look at the case of Palmer against Blue Circle, which talks about another complication, and that is where the employee has spent the money, not on day-to-day living expenses, but something else. They may try to raise a defence of estoppel. Now, this is very important. There's a commentary in the text about overpayment and set-off. And I think there are 2 or 3 cases mentioned there at the beginning about a set-off where an employer discovers they were obliged to make a payment and they want to rely on some other payment they've already made. And their argument is, well, look, I've already been overpaying these people, so can't I please have a set-off, because if I'm paying this additional amount, they're going to receive an unlooked-for benefit and receive a windfall. But look at some of the comments in 10.25 in the textbook about cases where the employer has come undone. If it's been paid over, even if it's well above award, on the basis that it's being paid as ordinary wages, it's no good coming back later and saying, well, okay, well, they were a bit better off anyway, so I should get a discount. If an amount's been agreed on for ordinary wages and paid, if it's been appropriated for wages, then the claim for payments, for example, for overtime or for other penalty rates, continues. The employee is still entitled to make that claim. Have a look at the case examples and they'll make sense of this. Look at cases around all-in rates, and I think that was the roofing case of Peters. What had happened there was that the parties really had agreed that they were being paid an amount which was going to include all of those different penalties, etc. So they'd turned their mind to more than just ordinary wages. If they're paid just for ordinary hours alone and it's been appropriated to wages, the employer will still be liable. And look at the comments about a couple of unusual situations. One where there was a special gratuity or a bonus that was paid. It's no good giving them a lump sum gratuity and saying, oh, well, that's going to be in lieu of your termination payment. It's going to still be payable. But look also at the ex gratia payment on termination, which was offset against a requirement to pay a bonus. I think those last couple of cases pretty much turn on their facts. The real issue for you is that employers who pick a figure, decide that it's well above award, pay that as ordinary wages, and then come unstuck later because they're meant to be paying overtime, can't have the benefit of setting off the additional amount that they've paid. They don't get any discount. And just to finish off the chapter, there's a reference to superannuation. It's paid under 2 Commonwealth Acts, and the idea has always been that it's cheaper for an employer to comply and pay the superannuation than pay the charge to the tax office. If you speak to a client, an employee who subsequently is trying to recover their unpaid superannuation, you need to tell them this, that their enforcement will happen through the tax office, so they'll need to make a complaint to the tax office. The tax office will then go after the company and seek to recover the amounts which should have been paid, and they'll do that under that guarantee provision on the basis that they're going to make a charge which exceeds the amount that's otherwise payable. Also note the comment that nowadays the tax office can also recover amounts from directors who didn't take reasonable steps to ensure compliance. So that's surely an incentive for companies and directors to make sure that they are paying their superannuation, although it's an often made complaint. If you do practice in this area, you'll realise that people come to see you about wages, and they also come to see you about their superannuation not being paid. Modern awards now contain a contribution clause, so it's clear that contractually, well, quasi-contractually, as well as under the Superannuation Act, there's an obligation to make those payments. All right, that's my comments about the issues for me for week 10. Next week we'll talk about working hours and leave, and that's the material which is contained in Chapter 11 in Stewart's Guide. We'll talk then.